It's,
Cool with
I
it.
mean,
I don't know if she's got a school thing.
It
or not
creates
tonight. It is
some
a
by
big
right
season for
that
them
even
over
if you
there.
have a non-conforming roof,
to go?
you can expand it up to 20%. Pushes from 20 to
Can't say that I
50% through a special
didn't
exception,
really love coming
and then
back.
prohibits everything above that,
We're going back on the 11th.
which I thought was pretty.
All right, good evening. Welcome to the
She said
November
that would make
19th.
us the most.
Welcome to the November 19th Plastow Planning Board meeting. Charlene, could you take the roll, please?
You bet. Richard Anthony,
Here.
Karen Robinson. Here. Dan Kane,
Here.
Rich Leclerc,
Here.
Nolan Pelletier,
Present.
Bill Coy,
Yeah.
and Shay Remaker.
Here.
Excellent. You have some minutes that if you haven't had an opportunity to review them, take a look at them now. And then we'll...
Do we accept the minutes?
November 5th,
November
2025. Right, I second it. All in favor?
Oops, sorry.
All in favor?
Aye.
Aye.
Opposed, abstained, so that's going to be 500. Right. Okay, first on the agenda, we have a public hearing, PB 25-12, the completeness of an application from J-Lams LLC for a lot line adjustment that proposes to transfer equal parcels of plus minus 27,560 square feet between 28 Main Street, tax map 18, lot 11 in the MDR zoning district, and 24 Main Street, tax map 18, lot 10, located in both the LDR and MDR zoning districts. J-Jams LLC is the owner of record of both parcels. The application is found to be complete. The planning board may immediately conduct a public hearing. I move to accept the application as complete for a lot line adjustment between 28 Main Street, tax map 18, lot 11, and 244 Main Street, tax map 18, lot 10, that exchanges equal portions of land and is described in the legal notice for PB 25-12. Wait a second.
Second.
Any discussion? All right, all in favor?
Aye.
Opposed? Abstained? All right, 500. All right. Good evening.
Good evening. Bill Hall with SEC and Associates. I'm representing the applicant for this lot line adjustment. Would I be able to pull the plans up on the screen here?
I should be able to momentarily.
Sure.
Would you state your name for the record, please?
Yeah, Bill Hall with SEC and Associates. Perfect, thank you. Okay. So what we have here is actually a reapplication for a lot line adjustment at 238 and there we go. No problem. And as you can see up here, the property is located along Main Street, and it's these two parcels here. And what we're doing is we're taking 27,560 square feet from this parcel here, extinguishing this lot line, and swapping it over to this side, maintaining frontage on this side for this parcel, and providing sheet. There's a number of restrictions there for access to get to that back parcel, so we won't have to relocate the driveway. And basically the reason why we're doing that is ultimately the goal is to adjust this lot line so that we can secure an access point for lot 10. And this is really the only point on Main Street along this frontage where we have adequate site distance for the access. So that's why we're doing this adjustment. It's pretty straightforward. And as I mentioned, it was before you before. The reason why we're back again is because there were conditions of approval that had to be met within 90 days. Of those conditions were we had to have a deed rewritten and we had to record a plan. That's all been taken care of. Unfortunately, it happened a little bit past that 90-day deadline, thus the need for this application. So those were, as I said, 2 previous conditions, and those are taken care of. I believe we have a letter here from the planning department where we have to add a well radius, I believe is what we have to add a well radius shown on the plan. We show the well, but the radius isn't on there, so we'll be adding that. That's not an issue for us. And I believe that's about it. Otherwise, it's as straightforward of an application as I think you can get. And I'd like to open it up to the board to see if you have any questions on it.
Again, just the question of the deeds. I mean, are we satisfied with whatever the deed was submitted, satisfied the deficiencies that we noted before?
That's my understanding.
Okay. All right, so if nothing's changed, anyone else have any questions or anything like that specific?
No, I thought we vetted this a fair amount the
Yes.
last time it was here. And I think the only thing we wanted to ensure is that the deed matched what was otherwise on the plan.
Yeah, so that deed's on record now, and we have a plan that matches that deed that's also recorded on the record.
Okay. I don't have any more questions.
All right. Is there anyone from the public that would like to speak?
I object to that.
You object to speaking at the public hearing?
I am James Mosher, tax map 18 lot 5. I objected to this last time. I'm just going to read a statement to you guys. I'm going to go to place with everything. Statement from James Mosher Jr. objecting the application of PB 2512 submitted by JJM MBS LLC. Dear Planning Board, Class of New Hampshire. I am James Mosher Jr. I am objecting to the JJM's LLC lot line adjustment application again. I reaffirm my previously stated objections submitted in my letter to Mr. Zilch, SEC, March 4th, 2025, and formally submitted to the Planning Board. I also read them aloud during the March 5th, 2025 meeting. All of those objections still apply. I am submitting another copy of those objections to the board to be included in the official record, together with a copy of this statement. Despite minor changes to the first page of the resubmitted application by JJMBS and Charlie Zilch's justification for the rear boundary line adjustment still relies on a court decision, case E20033-78, which the applicants haven't yet produced. I even met with 2 SEC employees to discuss this issue. They reviewed the materials and found no apparent support for the rear boundary line adjustment onto my property. Another SEC employee arrived, Brian Hines. He chastised the 2 employees I was speaking to and directed me to an office at the end of the hall. Unfortunately, Brian couldn't produce the court decision SEC continues to rely on for this 4+ acre adjustment to the rear boundary line onto my family's private property. As the board knows, an applicant who claims to have legal right to another's private land must produce a deed or court order showing they have that right. JJAMBS has not provided any supporting court order. JJAMBS is now producing a confirmatory warranty deed, recorded July 28th, 2025, book 6637, page 1907, along with a copy of the very same plan currently before the board, which they refer to as a boundary map, now recorded as Plan D45218. However, the legal description on this confirmatory warranty deed is an exact match to the legal description in JJM's original 2021 warranty deed, book 6249. page 329. In both legal descriptions still reconcile with the lot lines shown on the boundary plan D7674 recorded in 2021. The confirmatory deed does nothing to support the boundary adjustment that results in the taking of 4+ acres of my family's land. Also, their claim of ownership runs contrary to official town survey maps and records, as well as the New Hampshire court records, recorded deeds. The planning board cannot ignore these facts and their own records. The legitimacy of this newly minted confirmatory deed and plan is questionable. It is submitted by JJAMBS, who has been found in court records to have engaged in mortgage fraud in an attempt to help family member and named abutter avoid paying restitution after being arrested for title fraud within this last year. The information is a matter of public record and shown in New Hampshire State Police bulletins, New Hampshire Superior Court records. This information can be found in New Hampshire Superior Court Case 2118-2023 CV 01425, dated August 23, 2024, signed by the Honorable David W. Roof, who found that, in addition, the court finds the two mortgages made by Jordan Shallow on October 12, 2023, one to an insider, his father, George Kalil, and one to JJAMBS LLC, which LLC, his father is the controlling member. In that mortgage made to him on February 24th, JJAMBS LLC are fraudulent as to the plaintiff, and they were made and recorded improperly and to obstruct the ability to a plaintiff to collect payment on their outstanding judgment execution. As I previously stated, the legal description of the newly minted confirmatory deed that JJAMBS now using to support this application matches the legal description in JJAMBS original 2021 deed and does not support JJM's claims of ownership and request for adjustment of the rear boundary line taking 4+ acres of my family's land. Applicants must have a deed matching the site plan before the planning board. JJM still has not met this requirement, and the board has no option but to deny this application. JJAMBS would be required to file court action to obtain this rear boundary line adjustment. It is worth noting that the plan before this board does not even list my wife, Susan Mosier, as the co-owner of my property. That's it. That's it.
Is there a copy of the letter that you want to just pass on to?
Yes, I do.
Charlene.
With me, please.
No, you just give it a shot, Lean, right? So she can put it into the minutes.
You want it in the minutes
No.
instead.
Planning office here.
Okay.
Off to legal.
Anything else? I mean, we'll let you read your statement. I'm just going to say that, last time you were here, we continued things, I believe, to allow time for, if there was things that needed to be cleared up, you could, and it sounds like you did meet with, the applicant's agents. But in some sense, I think we're going to say the same thing, is that a lot of the things that you're arguing seem like they're not perhaps appropriately remedied in this form. So
the facts that,
well, we're not, in terms of if if the documents they presented are properly executed and things like that, and if there's some dispute that you have with them, I don't think this is the appropriate form, to continue those.
well, this is because this application should be denied. I mean, they're not providing the correct deed to matching the plan that they recorded since the last time we met. It shouldn't have been recorded. You approved his recording and told him to go change his deed. The last meeting. You can't do
And I
that.
believe the deed that we wanted sort of
And
a
he
clean
didn't meet
deed.
his timeline because they couldn't. And now they're trying to come up with this other.
No, they
mumbo
didn't.
jumbo.
They didn't meet the timeline, and they're refiling the application. Right. So everything's been submitted, and so this is where we're at.
Okay, well, I'm resubmitting this. I totally object. The lot lines are incorrect. His deed matches the deed D7764. His plan matches, the deed matches that plan exactly to a T. And it is not this one that he has submitted. Okay, this section in pink is all mine. You see that? Have you seen that?
I have, yeah. So, I mean, the problem is that that's not, what you're saying isn't
Problem
true.
is, you guys are
No.
ripping me off 5 acre. I'm not going to go
May I
any
respond?
further. Thank you for your time. Please look at all the records and the deeds and look them over. You'll see that I am correct. I have even talked to Susan, our assessor, and she agrees with what we're talking about. I am correct with my lot lines. I am correct about talking about the JJMs. So you can even check with her.
Okay,
But
thank you.
you should not forward this. Thank you.
Is there anyone else that would like to speak? Just provide your name and your address.
Certainly, I'd be happy to do that. My name is Kimberly Raymond. All right. I do not reside in this town. I reside in Kingston, but I own property here
Okay.
at 7 Linwood Street. It's really disturbing what's happening here, and I'm very concerned. I would have been more prepared. I had requested the materials timely and was told that I couldn't have them until the 17th when they were posted. I turned that request into a 91A request, saying, are you kidding? You don't have an electronic copy? And that was ignored. I got no response. So I've only recently received the materials. It's deeply concerning. It's deeply concerning also because
Can I just stop you for a second?
Certainly.
When did you put in your right to know? Just,
last week, I'd be happy to forward and will be forwarding more information to the board regarding what's going on Linwood Street. She seemed to suggest that it was going through some sort of vetting process. I know that the planning board,
who are you talking about?
D,
Okay.
okay? Some sort of vetting process to comply with the law and what you're supposed to do prior to reviewing an application. And it's disturbing to me that on this plan, as Mr. Mosier mentioned, his wife is omitted. And I'm going to tell you now, and I've been saying it before and asking about this, my now deceased mother, Elaine M. Schultz, is omitted from your records. The notices don't come in our names. The title has not been changed since her death. They're not listed on their maps. Recording such a document at a registry of deeds creates great risk for people in the community. That is an inaccurate representation of abutters. I believe the wetlands specialist also is not listed with his firm. He's referenced in the document, but he is not listed at the end.
Which document are you talking
The application before you, sir. His name is Timothy Ferwarda.
about?
My understanding is any kind of specialist that's used to support an application is also supposed to be provided their firm name and address, probably somewhere around the butters, where the butters are listed. That's omitted. I don't know how many other people are inaccurately portrayed as butters, besides myself and evidently the Mosiers. But another significant issue is the name of Linwood Street on their map is spelled incorrectly. That creates a real hazard at the Registry of Deeds and can create,
Just one thing at a time.
certainly,
Where on the map are you saying that, you know, I mean, is it in fact the case that Linwood is spelled incorrectly on this map somewhere?
Linwood
that's
is,
the old map, right?
no, this is a new
Oh,
one.
there it
Linwood is on the right side of
So
this
how is
map.
that spelled, sir?
It's spelled Lynnwood.
Okay. So I forgot to bring the town's official listing of street names. And if you had referred to them, you'd know that it was spelled Lynwood.
Sure, we can remove the extra N.
Well, it's already been recorded now at the Registry of Deeds, right?
This plan has not.
Wasn't it recorded as a boundary map?
there was a boundary plan that was recorded. I'm not sure how it's spelled on that. It's probably the same.
It's exactly the same. I believe it's a carbon copy of that map. Additionally, as I've testified here, even back in October 2023 on another matter, Linwood Street, I purchased a home at the end of a cul-de-sac. My house was the last house on the right. The Olette's house, number 12, was the last house on the left. And the terminus of the cul-de-sac was the Mosier's private driveway, formerly known as 11 Linwood Street. Their map makes it appear as if Linwood Street goes further than at the end. And all it shows is, I'm not sure, are those dotted lines supposed to represent an easement for Carlton
No.
Path? Because that's not reflecting a road, and your legend doesn't indicate what those dotted lines mean.
No, that'd just be the edge of it,
The edge of what?
of Carlton Path. We have the utility poles coming down here, so just the edge of the traveled way through there.
Yeah, I can't see that, but I don't see a street or a road lines like other streets. It looks like easement, the dotted lines. Is there a reason they're dotted?
Usually we would show dotted lines as gravel.
As
Not
what?
su- As like the edge of gravel, so edge of a travel way. It's not, if it's not pavement, then we would generally show it as a dashed line, like in that manner.
Okay, because my understanding is that Carlton Path actually refers to an easement that the town has that was litigated in 2014-ish, providing them a right to cross over the Mosier's property for a very limited purpose. 12-foot easement, very limited in scope. Okay? I understand that there's concern that that is being abused, and I would suggest it's still being abused.
Yeah, I just, like I said, specific to this application.
Yes.
I'm going to encourage you to be specific to
Yes.
this application. If you're referencing other things that are sort of in dispute,
Well, it's
which,
not-
I mean, admittedly, can we agree that there might be some sort of dispute, that's a little bit historical?
Respectfully, no.
So there's no dispute.
I've lived, Mr. Mosier's position is sound. I've lived there. I asked permission when I used to
It's not
walk my dogs
minimizing
up
it.
there.
He has a position, but what I'm saying that you're,
Yeah,
okay.
I understand what you're saying, but the course, they can't come in here with pretending that they have a lot line adjustment for the front for Main Street. And really, they're stealing 4 acres of the Mosier's property at the same time. At the same time, their rear line adjustment, they rely on a court order that hasn't been produced. They, I just lost my train of thought. They're relying on a court order that hasn't been produced. They were told to get a deed that matched. They needed to file a deed, right, that matched your plan.
Confirmatory
Yes.
deed, yeah, because the previous deed, when it was sold from 121A Realty Trust to J Jams, there was an error in that deed. To be clear, when Mr. Mosier said that there was an adjustment to the rear boundary, we're not proposing any adjustment to the rear boundary line here. There's no adjustment to that. There's no taking of his property. We went through all this research after the previous meetings and before the March meeting. We met with Mr. Mosier. What he has is what he has. When you look at his deeds, when you look at his plans,
So
they match.
The confirmatory deed you're talking about, I mean, if we're doing this, you're saying that nothing in the back end, this is referencing a dispute or something that might be happening with respect to the backside of the property and not what's happening up in the front in terms of.
Well, yeah, the back and the front are two separate things.
Right.
Yes, we're adjusting the boundary in the front, but what he has is, as far as what he has is deeded, the deeds match his plans. And when you draw the plans in, those areas match the deeds. So there's no dispute that we see from this rear boundary line. It matches his plans, it matches his deeds. Yes, there was an error in our deed, but that's corrected with this confirmatory deed. So throughout the title, there was an error in that. Those things happen. Sometimes something's omitted, it happens. That's why we always have to redo surveys, even though someone else might have done one. And oftentimes the way you do it, you run around the boundary and you pull the deeds for all the abutters and you make sure everything matches up. And in this case, that matches. So we did all our due diligence the last time around. I believe this was first presented in January, continued to March. In that period, we met with Mr. Mosier, and our licensed surveyor did not see anything that would change his opinion on this.
May I continue?
Yes.
If you read the legal description on the confirmatory deed, it's an exact match to the legal description on the prior deed, that the 2021 deed. It's an exact match. There's some language at the end that suggests, well, we meant to, some sort of extraneous language that really doesn't affect the legal description of the property. So they're the same. And they don't match the town's records, tax maps, surveys that were done. There's a gazillion records they don't match. And if you pulled the deeds, I'm curious why you didn't get the names of the abutters correct, because we've been having trouble with misuse.
Abutters, as far as on the plan, because we pull the abutters from the town records. So we'll get the abutters from the town record because we're required to have the abutters list that.
So they
Mail
didn't list
everything out.
both owners on the town's records that you pulled for my property, 7 Linwood
I
Street?
personally didn't do that myself, so I can't say for sure because I personally didn't do that. But what I can say is that's how we do it. And, we put now formally, that's what the N/F stands for on the plan for the abutters because these things change. That's why it's now or formally.
Well, it hasn't changed since 2004.
So just to distill it, I mean, are you saying that the required abutters weren't notified? I mean,
Saying that they're not
are you an abutter?
listed
Okay.
on these plans that will now be
That's-
recorded,
Right.
and they're inaccurate.
But in terms of notification, right,
Yes,
Where-
well, both parties were not listed, that's correct.
not listed, but
Yes.
are you one of the parties?
Yes, sir.
Okay, and you're here at the public hearing.
Yes, sir, I am. And since my mother's deceased,
Yeah.
I guess that's not an issue at this time, but she is still listed as a co-owner, and that is legally significant,
Okay.
okay? She has never lived on Linwood Street, but, I have just found a permit that was issued by the town listing her as a resident on Linwood Street. So there's a lot of problems down there.
Okay. but
I understand we
we're-
want to stay
we're talking-
focused
yeah, we
on
wanna
this.
Stay focused
Yes.
on this.
Well, I'm talking about town records and accuracy of plans.
So you got to narrow your focus a little more.
Well, what I'm going to continue to say about this is their plan makes it appear as if Linwood Street continues up the road. There is no terminus to show, and there's no listing that Carlton Path begins, which technically it was 11 Linwood Street. And as a matter of fact, somebody continues to use the Mosher's old 11 Linwood Street address. This is relevant and important.
To this lot line merger.
Yes, because actually, the abutter should know that you can go on to Zoom and other records, and they list Truello. They list Linwood Street as a 6-acre parcel that doesn't exist, and they show a picture of a portion of my property. This is what happens when maps aren't right and records aren't checked. Okay, I wrote to D because, as also shown on maps, it's now appearing that Linwood Street extends 45 to 99 numbering. Linwood Street ends at 7 and 12. D has not responded to my request confirming that, so I may take action. But I think their map inaccurately reflects that Linwood Street ends where it ends, and Carlton Path is not properly marked.
Okay, so Linwood Street and Carlton Path, you're saying it's not accurate in some fashion.
Yes,
But-
the abutters aren't accurate.
So
The name of the
my,
street.
my question then is that, if there were, how it's represented, is that material to the lot merger in any way?
No, I don't believe so. I believe what we have is an accurate representation of the lots for 238 and 244 Main
It's
Street.
in a certified surveyor signing,
Correct.
attesting to, these things. All right. Anything else?
Yes, yes. I'm an abutter and I have the legal right to speak about these things. This extension of taking of the Mosher's land, and again, the legal description matches the legal description in the prior deed. And it matches the other map. It does not match this rear boundary, and he references a rear boundary adjustment in the back of, in the first page of your, right? On the first page of the
There's
application?
no rear boundary adjustment. We're adjusting the boundary along the frontage of Main Street.
Sir, is this a copy? May I look? Because in your first application, it specific, and I regret not grabbing mine as I walked out the door. You specifically stated in the first application before the board that there was a rear boundary adjustment. And now they've modified it, and it was based on a court decision. So they've modified that sentence. May I? I can't.
It should be noted that the boundary at the rear of the lot along abutting parcel 18-5 was determined by a court decision.
Right.
But there is no reference to an adjustment because there is no adjustment that we're making to that.
Well, this is really quite shocking that you brought in this application, and on the initial plan, it said we are adjusting the rear boundary. This additional 4 acres now gives us 18 acres. They modified that, and it was based on a court order. They've now modified that sentence, and I'm not sure if they're pointing to this confirmatory deed and boundary deed to suggest that that is an accurate representation of that property.
It is, because as I stated before, Mr. Mosher's deeds and his plans all match. He has 3 separate deeds for this, for 3 separate parcels, and they match. They match his plans, they match his deeds. So in essence, what he is saying is because there was an error in our property here, he now has that parcel. But that's not how it works. If he's going to make some claim to this parcel, he needs to present the evidence in his deeds, in his plans, by going back through his title, which we did do, and we found no evidence of that.
What, you researched his title, you're saying?
We went through all his deeds and plans, yeah, because he came in, he met with us, and
Yeah.
he provided information, and nothing swayed our land surveyor.
Well, that is contrary to all the town's official surveys that they had done for the SALT litigation, or to the town's easement. It's contrary to the tax maps, and it's contrary to probably many other deeds and records.
Okay.
Their deed did not match. And I want to say, it feels like this lot line, front end lot line adjustment is cover for another taking of the Mosher's land. And to try and further cover up the taking that was granted by Mr. Greenwood being allowed to cross the Mosher's private property and build a home.
Okay. Is there anything else?
No, I think that's it.
Okay.
Thank you.
Is there anyone else that would like to speak?
Can I just add something?
If it's new,
Real quick.
if it's, please sit down and,
Yes.
and add new
I
information, please.
I just want to make sure that you guys take the time and look at this confirmatory deed and compare it to the original deed. And you'll see every measurement is exactly the same. It's just a bunch of mumbo different wording. But when it comes to a measurement, there's no change. the deed and the plan to a T. Just wording is different, so please take the time and look at that, and you'll see the difference. Okay, thank you.
Thank you. Anyone else like to speak to this particular matter?
Can I just ask a general question? So the lot line adjustments are two parcels, right? Two separate parcels.
Correct.
Have nothing to do with the back parcel, right?
That's correct.
So we're just sitting here looking at the lot line adjustment.
Yes.
Okay. I just don't see wading into a boundary dispute. We don't adjudicate those. That's not our job. We're here for a lot line adjustment on two parcels, and if there are Scrivener's errors on the plan, they're Scrivener's errors. Those can be rectified fairly quick. They don't, because of Scrivener errors on this plan, doesn't change any abutters' ownership, position, anything, And if I'm saying anything that's wrong here, just correct me. But I just don't see it. So the limit here is, what I see and what I'm concerned about is taking whatever dispute exists on a separate parcel of land and trying to merge it to stop the lot line adjustment. And I just don't think that's right. If you have a fight on the lot line on the back lot, go make that fight. But as it relates to the lot line adjustment, this is fairly simple and straightforward.
Can I make one comment, please? My understanding is that you have to have a deed that matches the plan that's before the board. Isn't that the ruling from last time? Their plan did not match their deed. That deed it's their plan, that confirmatory deed still does not match. So it's unjust to allow someone to record a map and put your signatures on it when the plan doesn't match the deed, and then tell the little guy, go fight it in court. Because the path that they should have to adjust that back rear lot, which is what they're doing, they admitted it and they fudged it a little in the first application and the second, would for them to go to court, to seek the court's adjudication of this lot line, not from the Mosier family to have to deal with all of this. It's overwhelming, and there is a real serious problem if people are rubber stamping these things and they don't match the plan. Thank you for letting me add that.
If I may, we don't
Please.
rubber stamp things. We don't fudge things. We have licenses that we depend on for our livelihood. So just to put that out there, we never do that. So that's actually insulting to hear that said, that we fudge things to make this
Wait,
work.
no.
And-
Hey,
I'm not-
excuse me.
And the second thing is, I believe that you had admitted earlier, Ms. Raymond had admitted earlier that there was some legal mumbo jumbo at the end of the deed of the new one, and that's what's important in the deed for the confirmatory deed. That was the change that was made, and that's what the important language is to correct it the way that it had to be corrected.
Let me first clarify, I wasn't talking about you rubber stamping. I was talking about the board rubber stamping.
Okay.
The deed needs to match the
Do you
plan.
have anything else you want to add?
Well, I wanted to clarify.
Well, I don't want to have a running debate back and
I
forth.
agree. I want to go
Fighting in
home. I
public.
don't even want to be here.
Okay.
Okay? So, I was not referring to you rubber stamping, sir.
Understood.
Okay? The little bit at the end, I understand the language there. It's sort of just reaffirming what was theirs. It really doesn't add anything, and the legal description stands. And that's what the law looks at. Those lines and those measurements and lines are identical in this new confirmatory deed. And it's not fair to allow him to grab, not you personally, of course, 4 acres and try and make them go fight these large institutions and deep-pocketed folks. Thank you for your
Thank you.
time.
All right. Anything else from the public? All right, so at this point, if there's nothing, then we would close the public hearing and then we would deliberate and vote, right? I think, no? All right. I concur with what Mr. Kane saying.
Did we close the public hearing?
Yeah, we're going to close the public hearing at 7:11. All right, then we can talk now, I guess. I agree with Mr. Kane, just in the sense that what we're being asked to do here is, a lot line adjustment. It sounds like there's, a lot of other, there may be ongoing issues that are happening here that I don't think that the planning board is necessarily the appropriate forum for. So, I mean, and I think we said that last time when this application was in front of us. We asked that if there were questions with respect to the deeds, we asked that the applicant go back and sort of remedy those discrepancies. They've been remedied, and so we're being asked to look at the matter before us and not it seems to be the historical issues associated with this. That's just my thoughts on the subject.
Have the deeds been remedied though? Do we know that for a fact?
I want to say that.
Yeah, I mean, this sounds like there's a big problem here. May or may not be, but we don't know how to read those deeds and know what's right and wrong. That's not our job.
All right, so Shay, do we have this? Do we have those deeds? And I mean, is there something that we're, that it was like they need to be remedied and they've been remedied?
Per the last application that was submitted, one of the conditions of approval was requested by the board was to get an updated recorded deed reflective of the current boundary survey.
See that.
And an updated deed has been submitted and recorded and was submitted with this application.
Here's the thing is, it's just my view is, we're not here to arbitrate deeds.
Mm-hmm.
If a deed is presented to us and it matches the property as our hands are, we can only act on what's before us.
Correct.
And what's before us is a simple lot line adjustment. And I'm sympathetic to people's property rights, big time, but asking us to do something, we're not, if you will, competent to do.
Well,
To be-
true statement.
to
competent
just, yes, in terms of, determining deed. We have a surveyor's, signed plan. We have seen the confirmatory deed. To me, our responsibility is fairly narrow here.
Yep.
Yep.
Yep, I agree. As long as the stuff was put in play, they say it's accurate. Engineers don't lie. That's, if they just don't. So it is what it is.
Yeah, no, and as Dan said, the only thing in front of us is the lot line
Right.
adjustment. That's all we're looking at.
All right, so I move to approve the lot line adjustment between 238 Main Street, tax map 18, lot 11, and 244 Main Street, tax map 18, lot 10, that exchanges equal plus or minus 27,560 square feet areas of land is described in the legal notice of PB 25-12 with the following conditions. The final recording plans will have all the applicable professional stamps affixed. Monumentation certification by a New Hampshire licensed land surveyor is submitted to the planning department. The protective radius for the existing well will be added to the recording plans. All conditions are met and recording materials are submitted to the planning department within 60 days of the conditional approvals. Do I have a second?
I second.
Any additional discussion? Again, I think what we have before us is a lot line adjustment. And And that's what we're making a decision on. And if there are any other disputes that people have, then they should probably be addressed in the appropriate or competent forum. And the planning board is, in this matter, I don't think is. So, any other discussion? All right, all in favor? Aye. Opposed? Abstain? All right, so it's going to be 401. Is that right? All right. Let's see, is there anything else I need to read into the record?
To read into the record.
The bonding? The whole thing? Bonding. There are no infrastructure. Right. There are no infrastructure or site work being. All right, excuse me. Excuse me. We're having a meeting, all right, and everyone will conduct themselves appropriately. That's fine. All right, but right now, conduct ourselves appropriately. Thank you. All right, bonding. There are no infrastructure or site work being proposed under this plan that would require bonding. L-chip fee. There will also be an L-chip fee of $25 payable to the Rockingham County Registry of Deeds, required at the time of recording. Please. Deed recordings. Once the lot line adjustment plan is recorded, it is the applicant's responsibility to have new deeds prepared and recorded that will reflect the new dimensions of the lot. Impact fees. There are no applicable impact fees for a lot line adjustment. All right. Do we want to take maybe like a 5?
Can we take a
10-minute break?
5-minute recess?
Yeah, we're going to take a 5-minute, 10-minute recess.
Yeah.
Is Sherry's getting killed up there? Is Sherry's getting killed up there?
All right. Welcome back to the November 19th Plastow Planning Board meeting. Next on the agenda, once we get action here.
There we go.
All right, welcome back to the November 19th Plastow Planning Board meeting. Next on the agenda, Planning Board 25-13, public hearing. The completeness of an application from Charles Hilbert for a special event permit to allow Christmas tree sales at 31 Garden Road, tax map 26, lot 49 in the C1 zoning district. RIGZ Enterprises LLC is the property owner of record. The application is found to be complete. Planning board may immediately conduct a public hearing.
Merry Christmas.
Thank you. Should we look at both of these at the same time?
I kind of think so, yeah, right.
No, I'm
Yeah.
looking at it because they're two programs. I open one and close one, so I'd open them both
Yeah,
at the same
right.
time. 'Cause it's going to be, right?
It'll be a whole lot easier to explain, especially with the one you started with.
Right, that's, from looking at, that's what I figured, right?
All right, so, well, in keeping with that, then we'll open the public hearing PB 25-14 in conjunction with PB 25-13. PB 25-14, the completeness of an application from Charles Hilbert for a special event permit to allow Christmas tree sales at 63 Plastow Road, tax map 27, lot 43 in the C1 zoning district. PEAM Realty LLC is the property owner of record. The application is found to be complete. The planning board may immediately conduct the public hearing. So with respect to PB 23 13, okay. So. All right, I move to accept the application for a special event permit for Hilbert's Plantation hold Christmas tree sales at 31 Gardner Road, tax map 26, lot 49 in the C1 zoning district that's complete as described in the legal notice for PB 25-13. Do I have a second?
Second.
All right. Any discussion? All right, all in favor? Aye. Opposed? Abstained? All right, 500. All right, then we'll do the, I move to accept the application for a special permit event for Hilbert's Plantation to hold Christmas tree sales at 63 Plastow Road, tax map 27, lot 43 in the C1 zoning district as complete as described in the legal notice for PB 25-14. Do I have a second?
Second.
All in favor? Any discussion? No? All right, all in
Aye.
favor?
Aye.
Aye, opposed, abstained? All right.
That was simple enough.
Go sell some Christmas trees.
Thank you very much.
Wish you
We're
luck.
intrigued.
Well, they were supposed to have a tenant going into 63, so that was why we covered our bases.
What is 63? What's that?
It's Westville Supply.
The old,
City used to be in.
sure, the city.
Yeah.
But I guess there's a food business that wants to go in there, and the permitting process is quite,
We knew that we had two areas,
Yeah.
obviously.
So that one's going to be open then, I guess.
well, I'm hoping to be right up front with you. I'm hoping to put like 10 trees down at the new city location with a sign, because I know you don't allow off-site signs, just saying that we moved up over the hill.
We do, but you charge
Because
for it.
it's amazing the difference. I've been in many locations over the last 25 years,
I know.
and before Walmart and after Walmart
Big difference.
is a big
Big
difference.
difference.
So
Big difference.
where the city is now, it'd be crowded, it'll be busy, but the traffic flow is phenomenal, where it's much easier, much simpler up over the hill,
Sure it is.
but the traffic flow is half.
Yeah, it is.
You know.
It is. And if you past Cumbies, it drops even further.
Yeah,
Yep.
yeah, because
Did you used to be at the old where the Dano's building was years ago? Was that you too?
I was in front of Bradley's.
Bradley's.
Yeah, because I remember you were there.
Dating ourselves really bad
That's
here.
where the new clinic is.
Yeah, you
I
were
was
in-
where
he's
Hope
used-
Steiner is.
he's used
I
to
was where
be-
Tractor
So that's all you?
Supply is.
Okay.
Like I said, my family, we grow our own trees, and we've been selling our trees in Plastow for close to 30 years.
Good for you.
Yeah.
Ever
Good for you.
since Door Brothers left.
Good for you.
Yeah, so you've been up past there for a while anyway, so.
Yeah, it's
Traffic
nice.
flow is amazing
I was
how it
across the
drops.
street at the hydraulic place for a year.
Yeah.
Yeah, there's not too many locations I haven't been in, but it seems like as soon as I go there, somebody says, hey, that'd be a good place to build something.
Yeah.
Let me-
That's-
let me-
that's- Blast
Maybe we
out.
should move you around a little.
Yeah,
bit.
right.
Maybe I should be a consultant instead of a tree filler.
Maybe we put them on the Demoulas lot.
Oh,
I
geez.
tried, it's in court. I tried to go there.
Oh,
I did. I told him, I said, I'll clear it out. I'll,
the traffic light and everything there.
yeah, because I do business with Demoulas when Bradley's was there, but Coles wouldn't allow it. And I do business with Coles in front of Coles, but Market Basket still owned it over in North Andover.
Right.
So I'm very tight with Market Basket, and I tried to go up there because I figured, hey, there I could be there for a few years.
Just a piece of dirt sitting there.
Yeah, but it's tied up in litigation.
Really?
So I was
Interesting.
like,
I wonder why.
So are you looking to, to get permits for both of these or one of them?
I would
Or a
I would be
particular one?
thrilled if you would be willing to do that, just to put like 10 trees out in front of the new location, because he's a great guy, but he's a little concerned with it being overcrowded with the parking, not with where my trees would go, but because of his customers and my
And
customers.
that's understandable.
So,
Yeah.
right,
Rich,
so
Rich is
I
pretty,
mean,
Rich is pretty cool. I know.
he's awesome.
Yeah.
He's
So
awesome.
what you'd like to do is just put 10 trees or so at the other one, let people know.
And a sign,
Trees
because
up
then I'm
for-
technically not an off-site sign,
Right.
correct? Or am
Right.
I
No,
assuming too much?
No.
no. I don't see any problem with this at all.
Yeah, I don't.
So,
I don't see any
It
problem with
was,
this
it
at
was a
all.
lot of money to spend to put up a sign.
It would have been nice though if you brought us in some hot chocolate or something.
I could have brought you some snow.
Oh, all set. All
I showed
set.
her the pictures.
All set with the snow.
No snow.
No snow.
All right, I'll make a note. Next time,
Anti-snow.
and there will be a next time, because I'm sure I'm going to have to move again. But
So just so we know, you'll have the 10 trees where the new city is.
yes,
And you'll have your bulk of everything.
Where the old city was.
yes, where the wreath, right.
Sign saying to go.
Yep.
Yeah, I think.
Just to make it clear for everyone.
Yeah, no.
That's
That way I'm not breaking any rules,
What do we need?
no
for-
And
off-site.
you're helping the public too.
You could just do it, right?
It's all about small
We
business.
can't let Home Depot and Walmart have all the Christmas sales.
All right, so we'll-
Or Amazon.
both locations.
Thank you very
For
much.
Amazon next.
Oh,
Oh, hang on, we just gotta do the,
is there anyone in the public that wishes to speak on this?
yeah,
All right. Okay. So,
let's see.
all right. So in
Let's see.
terms of closing the public hearing,
I can combine the,
so we'll close the public hearing at 7:29.
and we can just combine the two motions, right?
Yeah.
So I move to approve the application for special event permit for Hibbett's Plantation to hold Christmas tree sales at 63 Garden Road, tax map 27, lot 43, in the C1 zoning district, as described in the legal notice for PB number 25-14. And also for special event permit for Hibbett's Plantation to hold Christmas tree sales at 31 Garden Road, tax map 26, lot 49, in the C1 zoning district, as described in the legal notice for PB 25-13.
Can I ask, is it 63 Plastow Road or
Yeah.
Garden Road?
No,
What?
63 Plastow and
Okay.
31 Garden.
Okay, so
Oh, yeah.
just
Yeah,
modify
right, the old
that.
way.
Yeah, we'll just make that change.
Yeah.
Garden, That's right.
63 Plastow Road.
Right.
Okay.
It's actually Garden Road.
Yeah,
Yep,
where the
63
new
Plastow,
location of the
31
city
Garden
is.
Road. Yep.
Yeah.
I see.
Made by Bill, second by Karen. Any discussion? All right, all in favor?
Aye.
Aye. Opposed? Abstained? Excellent.
Awesome.
Good luck, Merry Christmas.
Merry
Thank
Christmas.
you.
Sell some trees.
I do have one quick question. I need to get a sign permit for both places, correct?
Sign permit.
Or does that fall under
Yes.
this?
You have a sign at both locations, probably, but that's building department, so I would talk with them.
Yeah.
Okay, super.
Right there.
Will do. Thank you again.
Very good.
Thank you.
You.
Merry Christmas.
Merry Christmas.
Merry Christmas.
I didn't realize they grew their own trees. I thought they'd come out and live there. You do? Oh, that's his family? I had no idea.
All right, let's reorient here for a second. Where is my,
Yeah, they used to be on the old, where the old Dingos was, the TP building. They did for years.
all right.
Years.
Next on the agenda, conceptual consultation for Jones Danville Realty Trust, 14 Danville
Jones is
Road,
right there.
Plastow, New Hampshire.
Davy
Tax
Jones.
map 30, lot 86. Welcome.
Welcome.
Thank you. Tonight, we may be discussing a plan, and you may have it in your packet, but I have this little bit larger size, if it would be helpful. On this size, it's decent.
Here we go. I can still read small print, but that's me.
All right.
No, I think what we have is good.
Perfect. Okay, thank you. Let me introduce myself. My name is Derek Lick.
Oh, here it is.
I'm with the Orono Reno office up in Concord. I'm joined tonight by the property owner, David Jones. And we are here tonight for a consultation for concept. And we basically want to get input from all of you. But if we would, I'd like to explain the situation and then seek your input. So Mr. Jones has owned the property for 3 to 4 years now. As you may know, if you're familiar with the property, he has Neighbors Oil. And this is a 4-bay garage, is that correct? 4?
Yes.
Yeah, 4-bay garage, and there's a house on the lot and all of that. He acquired this from the prior owner who ran a trucking business out of the site. And essentially, after acquiring the property, Ms. Voss reached out, and there was a question about zoning and whether or not his current use there was appropriate for the zone. We received a recent zoning determination from Ms. Voss that what Mr. Jones is utilizing the property for, essentially storing his trucks inside the bay, maybe having people make a payment here and there in the office in the back. And then he also, in the summer months, will use that as sort of a base of operations for a landscaping business. He doesn't store any materials there or anything like that, but it really is sort of the home base. So that's the current use. When Ms. Voss issued her zoning determination, she thought that we should be coming before the planning board, potentially for a site review. And we wanted to get input from you on that, and if so, what you guys are looking for. From Mr. Jones's perspective, it was previously used to put equipment in the garage and have vehicles in there. That's exactly what he's doing today. But we understand that the town may want to have a different view of that. And if there are issues that you have with the lot, you want, there will be no physical, he plans no physical changes if that's permitted by the town. So given that he's not really doing anything different to the lot, and it's just technically a change of use, I guess it's oil trucks and landscaping trucks every now and then versus other trucks, but I don't know. We want to hear what you guys have to say. So we want to know if you're familiar with the property, if you have any questions about it or any concerns, and then we want to know if we're going through site plan review, what it is you folks would like us to focus on. If you have particular concerns, we want to hear about them. So that's where we are, and I don't know if you guys might have questions or not, but that's what we're here for.
I think, do we have a copy of the zoning determination opinion or anything like that? You said that you got from Ms. Voss?
I did not bring one with me. I'm sorry. I thought it was in the file for all
Oh,
of you, but I apologize.
Shay, do we have that, or
I don't believe it was submitted with the application
That's
for
right.
the conceptual consultation, so. I didn't provide it.
Yeah, I mean, I'd just be curious to know what was said with respect to zoning, anyways. So,
Yeah, the short version of
Yeah.
it was that it is essentially an allowed business in the area. With the landscaping business, the question was, and there's a distinction in the town ordinance with respect to landscaping businesses where you store materials on site, and then those businesses where you do not. And because he is not, if he was storing materials on site, it would be a different type of use. And there would be, I'm not sure if there's a variance or a special exception, but some kind of approval would be required. But so long as he does not store materials on site, the zoning is fine and he's allowed to do it as far as the zoning ordinance is concerned.
So right now, he's likely considered a trade business, right? Under the definition of the zoning
Yeah, I
ordinance.
think that's correct.
Okay.
Excuse me, you will have to talk loud because age is starting to deaf me. And in my line of work, I break every hearing aid.
Oh, yeah. Oh, yeah.
Plus every bone.
Oh, yeah.
Yeah, so
the oil trucks, are they going to have material in them? I mean,
So the question is whether the trucks have material in them as they're in the garage, I guess.
No. In my line of work, you have to be smart enough to order precisely what you need day to day. And that's how I live.
And then you go.
It's cost effective if you order the right
So
material.
what you would do then in the morning, you'd go fill up the truck somewhere else, make your deliveries, and then
Right.
the trucks come back.
To be honest, it could be a couple 100 gallons on it.
I delivered oil at one point, so I understand.
You know, you think you're empty, you look in, you got 50 gallons, even if the meter says you're empty, you know what I mean? So, and it does depend on temperature, because in a cold season, if you have 10 gallons in it, it can grow.
Yeah.
So
Not a whole lot more than a fuel tank.
Right.
that's why people order oil on a cold day in a warm house.
I don't see a lot of difference here in use, that's for sure.
So,
Yeah, so
I mean,
we're not talking any oil tanks you're
No.
looking to put up. There's no oil tanks. Anytime you get oil, it's going to be off-site. So you're not going to have, right, there's no oil tanks. It's gonna
It
be-
literally is just storing trucks inside for
So
sale.
that's all we're talking
Not
about.
storing
Yes,
the oil.
it's-
so
it's just-
one of the things you just have to worry about is if there's oil in the trucks as they're being stored. You know, oil's a regulated substance under our zoning ordinance. So, you know,
In
not,
today's world, in the oil business, you don't buy in advance. We're driven by the market,
Yeah, day
by the hour.
to day.
So
but you-
we have to even cancel pickups. Like yesterday, it went up 15.4 cents.
I think the concern is rather if you have, let's say, residual.
yeah, it's not,
oil.
it's not your storage. You're going to have oil in those trucks at some point in time if you're delivering oil. You're not coming back bone dry.
So what is the
Well,
the requirement then if it's?
I mean, there's no necessary requirement. It's just considered a regulated, and you start getting into the hazardous material and all that aspects of the zoning ordinance. And I'm not saying it's a prohibitive action, but it's just you're asking about what to think about. That's one thing to think about, I think.
Fair enough.
It's not necessarily an outright barrier, and maybe there's some mitigation. I don't know enough about the storage of oil per se, but it would be hard for me to believe that it's going to be zero.
Oh, it won't be zero, but it'll be small.
Yeah.
I mean,
Very small.
there'll always be something. It's like,
course.
you're always going to have gas in your truck and all that. There's always
Well,
going to be something.
they're already storing trucks there now.
If you're
so-
driving a diesel truck, you probably got a 50-gallon tank in it. It's probably got no more gas, no more fuel than that.
Yeah.
So what's the difference?
Right.
Because I know people in the oil business actually, they do not store oil in those trucks. They pick it up in Chelsea, they sell it, and the trucks come back virtually empty. And that's the way it works.
Yeah, the old days when I used to deliver
That's the-
oil, we had our own tanks and we used to fill them in the back.
But that's the word.
No.
The word there is virtually.
Yeah.
It's not empty.
No, nothing's empty, but again, you're talking about such a small amount that it's no more than a gas tank on a diesel pickup truck.
Well, so if we're looking to have, things to think about, then that's going to be it. I mean, if you're talking about, you're going to have to consider, hazardous material type. What's the threshold, if there is going to be a threshold?
How many trucks?
I didn't hear you.
How many trucks? Dave?
3.
Three. Okay.
The reason they're stored in the heated garage is for safety. Because anyone with trucks knows that when the cold snaps come, it can cause effects mechanically, anything, any truck. That's why the good guys, not just oil, good truck drivers keep them heated.
I must admit, whenever David approached me, one of the questions I had, when I look at planning boards, I think of things like lighting, traffic, is there sufficient parking, those kinds of things. And from what he's telling me, there's basically no more vehicles parked there than was always been there. Whereas before, I think it had, a while ago, I guess, it used to be a used car lot. And so there was like parking up front for
Yeah,
people
there
for
was.
display of cars and all that, but there's none of that. The lighting, it's not like he's displaying stuff with overhead lighting at night kind of thing. That's why a little bit why I'm struggling. He has a survey that was prepared when it last came before the town. Was it 1998? And if he must, of course, I'll advise him to go get a brand new survey to go draw the same property lines and put in the same exact. I don't know if this gentleman is still around, but I'd ask him, can we just use your plan and change the name and identify that there will be fuel trucks and landscaping? But it seems a bit overkill for me, but you guys are the ones that make the decision about what you guys need from us. I have reached agreements with towns in similar situations where we essentially do an agreement, where you just identify the use. And for example, you could say, the planning board reaches a determination that site plan is not necessary so long as, for example, no more than 3 trucks. They can't store fuel with that. But again, that's why I wanted to feel you guys out and get a sense of, do you have concerns? And if I'm hiring or he's hiring a surveyor or an engineer to do a site plan, what is it that you would want us to show that's
any different?
That's different, because we're not changing anything.
Yeah, and I think on the surface, I tend to agree. Shay, was this site plan recorded at Rockingham?
It is, yes. Okay. It's got a plan number on it.
Okay. No, I saw that, but I just wanted to make sure.
I can say there is only one change I would like to make, and that is to remove some of the pavement. I've looked at approximately 800 square feet of pavement. I'd rather not have the pavement.
What are you going to put
If you're not
there?
using it, why have it?
What are you going to put there? We're going to put something there or just remove the pavement? Are you going to put something there?
Are you putting something there?
Yeah, I put a lawn.
Oh. Who's going to cut it?
Me. I mean,
No.
I do have to make ground improvement to the whole property. First of all, I'm a workaholic, so it's a serious illness. But
Well known, trust me.
I just want to improve it, every inch of the square footage, and
Drainage.
I've already pulled out stumps. The state had trees cut down, I guess. I pulled the stumps out. Along Danville Road, I do have to make some modifications to the grade of the land, because I don't know what the state's putting on the road now, but it comes right through the property all the way down to one of the town drains. But it kills everything on the way in.
Yeah.
So I'm going to level it off.
Hey, David, don't talk your way into a site plan.
Yeah.
All right, I'll leave it alone then. I'll put the stump back.
We didn't hear anything.
No good deed goes unpunished. Don't solve a drainage problem.
Well, and I think where you were kind of talking about is generally where, at least for me, I would be headed is probably, I could see my way to not worrying too much about, having a new site plan if nothing on the site really changes, other than now maybe some conditions as to the things that I would worry about, which is the oil that, that has a big, if it's only 3 trucks, that doesn't seem to me to warrant too much other, severe requirements or anything like that. But
So you said the trucks are being stored though, inside, right?
Yeah. I think in terms of a conceptual, I could certainly see this as moving to, some sort of approval, without necessarily a new site plan.
I'm curious, as a process, do you think, I'm trying to brainstorm, we would come back maybe for a continued conceptual discussion with me providing in advance some form of a agreement or a decision where you basically say, we've reviewed this, we don't deem a site plan necessary. However, for this use to be permitted, we find it only if again, only 3 trucks, don't store fuel, whatever it
Yeah,
may
so just
be.
the conditions. just
How
the-
many bays does this building have?
Four.
Four. I would limit it to.
We would be able to have this reviewed by our consultant, Mr. Keach, right, correct?
If the board would like that, yes.
Yeah, I mean, it's just, in terms, because I guess my concern is that if we're doing, if there's a question of potentially hazardous material, and I'm just saying that if it's de minimis or not, what types of conditions would be appropriate, to kind of include, at least from just sort of an engineering.
I don't want to cause myself any problems, but there's also 4 monitoring wells on the site, 2 right in front of the building.
Yeah, I think the only real concern here is just the fuel storage, that this doesn't happen.
Yeah, inside,
I
yeah.
mean, he's not going to put a full tank of oil in there.
But I think,
No, because you're always gonna go to a depot to get
Go
filled
to
up.
Chelsea, you
You're
get
not
the
gonna
load.
put your own tank there to start filling trucks
Yeah,
up.
but I
That's what
think
we
it's-
did, that's what we did in the old days when I delivered oil.
Yeah,
We'd fill up
no.
our own tanks in the back and off we'd go.
I know a few people in the business.
Like
Pick it
I
up,
said
they
a
deliver
minute
it,
ago,
and the truck's
we have
empty.
to buy by the minute and
Yeah.
use it that day.
Yeah, yep.
It's not because we'd like to have strict schedules, but today's market, boy,
No, no.
No, it's a different.
could you had indicated that you would be willing to kind of put forward, maybe your idea of
Range of conditions.
whatever your conditions are. I think I'd want our consultant to review it and just, in terms of like, if he feels that there are any other additional conditions that should be included in it that would perhaps.
I mean, you basically start now getting into, an application, and then, at that point in time, we can say, hey, you don't need a full site plan, but,
Just list.
here's some conditions that are going to end up being recorded on something that gets, that gets recorded.
Well, then what are the mechanics of that, Shay?
Um,
If we're hypothetically looking to move towards just having like a set of conditions, all right, and we're in a conceptual.
My suggestion, I serve on a zoning board, and in a zoning context, sometimes applicants come to us, and the question is, does this need zoning review? For example, we had one situation where it was a garage, and the question was whether it was an attached garage or not. It had a breezeway, and under our ordinance, if it was deemed attached, you didn't, or vice versa. So we ultimately made a decision in that case that based on the application as presented, we determined that no, in that case, I think special exception was necessary, I could envision a similar scenario here where we come to you with a continued conceptual review and you provide a decision that essentially says, based on the consultation review and the information provided, no site plan review is required so long as
Yeah, I'm not so sure. I mean, conceptually, I'm just looking at process-wise.
Yep.
I think you're into an amended site plan, no different than we just went through with the old ProQuip. We didn't require them to
No.
prepare a new site plan. They filed an amended site plan that had some conditions. We had
Yep.
no left turn there and
That's a
stuff
good-
like
That's a
that.
good analogy.
I like that.
Yep.
That's a good suggestion. Would you be okay if we submitted this plan, basically asking to amend it for the conditions, with the use?
That's what we did.
Yeah,
That's effectively what
exactly
you
what we
would
did.
do.
Yeah, because I think that's what you would do, and then we'd review it, and if we made some changes, we'd make some changes.
Yeah.
I mean, Shay, you got,
It saves time, saves money on everybody. It's just, it gets it done.
Saves the money.
I like
It's
that
done.
suggestion. Thank
It's
you.
done.
That's a good idea.
no, Shay, you got any insight on this one, or?
Yeah, I was just gonna say that, the board previously did this where they had an applicant come forward for a conceptual, and then they went through the amended site plan process, but didn't create a new survey to be recorded, and there were some conditions attached. But that plan is just held with the planning department here, and then the notice of decision was recorded at the Rockingham Registry of Deeds. so
Okay,
that
thank you.
if anyone wanted that notice of decision was still on record and could be found.
And with your permission, what I would do is talk with you about, you got a big checklist, right, for the site plan review. So I'd have to figure out like, what do you need and what do you not need? I think,
And we would still be able to have the engineer look at it then in this context, if we're doing an amended site plan. Right, so if there's any expertise that we would want to weigh in, again, I'm looking at it from the perspective of potentially, just the material being deemed hazardous in some way.
so it sounds like well, first I should just ask, generally you guys seem okay with the concept with some conditions, and I think what I'll do is talk with David, and the plan will be to submit some form of application for amended site plan review or amendment to site plan. Providing this plan, maybe with a specific description of what is envisioned, and maybe even with a proposed finding or ruling or something that you guys can use. I'm sure you'll do your own thing, but at least you'll have a concept. And I can even provide it in Word to the extent you guys want to tinker with it. So does that sound, looking around the room, is that okay?
I think that sounds.
We've done this dance before.
Great, well, thank you. This is very helpful to us, and I know David appreciates it, trying to navigate doing the right thing. So thank you. Thank you all. Any
I
other
appreciate whatever you're saying, but I'm much more,
But he can't hear a
I'm much
damn word of
more
it.
fortunate than you folks tonight, because I can't hear you, and whatever you had to listen to, I don't.
All right,
Well, thank you. We'll be back to you soon, and I appreciate the time.
very good.
Thank you.
Thank you.
Everyone,
Thank you very much.
have a good
Happy
day.
Thanksgiving.
Oh, yeah, that's right. That's next week.
When's that, next week?
Yep.
Get it.
Do I have to take the day off?
Get a new hearing aid.
I keep breaking them, you know what I do for a living. They don't go good with heavy equipment, or even a shovel.
He almost got killed a few years ago in front of Dan's house.
Thank you.
It was bad. But he's a good guy. He's a good guy.
All right.
I think that's fair.
All right, we have, good night, good night. We want to deal with these memoranda first, and then we'll
Sure.
dive into the,
Where are these now?
all right, so. Let's see, what do we have here? We're going to look at the various, there are two memoranda.
A chapel in their house? Okay.
All right, so with respect to, what is it that we're being asked to look at here with respect to the zoning amendment proposal for construction hours?
Why don't we just deal with that when we get to that?
What? Oh, you
Yeah.
you think that it would segue nice
Yeah,
into the
I
zoning
do.
amendment?
It's easy. It's already there. Just
Is
look
the
at-
other memorandum addressed there by whatever's in the amendments, or do we,
what amendment?
one with respect to the chapel, religious occupancy?
So, no, but I think we should chat with this one just a bit, because it's, first of all, I think of it as a third rail, personally. Really want to stay away from
Oh, yeah.
regulating any idea of worship. So,
Oh, yeah.
Well, just
Oh, yeah.
just before we say that, though, it's, let's provide a little context with respect to religious sites. I mean, by right, you can have.
well, here's the thing. There's two things. There's a few years back with COVID, the state, ended up with a lot of private churches, popping up. So the state turned around and said, all right, we're gonna create our own statute. And basically the operative word is no zoning ordinance or site plan review regulation shall prohibit, regulate, or restrict the use of land or structures primarily used for religious purposes. So it takes that. And, I wouldn't focus too much on the word primarily, because here the specific trumps the general, in a sense. I've I've virtually not seen anything at the state level where the major restriction on something would otherwise be trumped by a minor restriction on it. And in here, as I understand the use, Shay, it's fairly minor and occasional. Is that fair enough?
Yes.
Okay.
So it's
So-
not becoming a church.
Yeah,
or a
it's
house of- whole house of
apparently a
worship.
chapel. Yeah. And it doesn't fit into the definition of home occupation, you know?
Nope.
Because that is clearly in the ordinance as an accessory business type. You know, nothing of this relates to business, you know, churches aren't business. The nuance here is that it is a non-residential use, you know, so theoretically could come under the planning board. I'm having a hard time beyond just the non-residential nature. And I think we get trumped, you know, if someone was of a mind to look at this, they get trumped by the state,
Oh, yeah.
you know. One guy's view is there's nothing here for us to do, you know. If the enforcement arm of the town wants to take a look at stuff, that's certainly in their lane. If the ZBA wants to take a look at stuff, that's certainly in their lane. I don't think there's any role for the planning board here.
Totally agree.
And one thing too is in our definitions in Article 2, this happened to be a fairly timely, because the attorney and I were we put worship, if you will, as a permitted use in every district, because essentially that's the way it works. And the definition that was in the ordinance, I placed in there because we didn't have one, but when I looked at it, it was more formal and churchy. So when we go through the definitions, I'll read it, and I broadened it to make it not narrow.
Right.
Okay.
So that's my 2 cents on that, is just
Stay away from it.
Yep.
stay away from it.
Far, far away.
And we can, if you want, I can draft a little something and just send it back to Bob and just
So, but just by way of consensus.
say, if you want to step on the third rail, go ahead, but we don't.
Yeah, so by way of just consensus, then maybe we just send something, respond to the Mr. Donovan, indicating that we don't think that there's really a role for the planning board to speak to this.
Out of curiosity, how did this even come up? That's a very odd topic.
Perhaps some,
Just curious, how did this come up?
context.
So I received a call from someone who was looking to do this on a property in town.
Okay.
And
Was it a
so
complaint?
it was not a complaint.
Okay.
No, this use isn't existing. This person was looking at purchasing a property. But then it came up as to where this would fall within the zoning. And when it was brought up with code enforcement, building inspector, we talked about home occupations potentially coming up. And then the process in there for an unlisted profession says that the code enforcement building officer can determine where it falls under home operations with consultation with the planning board, which is how this memorandum.
Okay.
ended up.
I was wondering if it was like some kind of a complaint or something. I can't
No,
imagine, but who knows?
what happens is you have the definition of home occupation,
Right,
which
and
drives
doesn't
it,
fall in there.
and that's an accessory business use. And then the determination falls under there.
They're doing the right thing.
Do you get a tax break if you have a
If you wanna go
chapel in
for a
your
tax
house?
break.
I don't know.
Because I think, with the increasing taxes, I might have my own chapel.
Well, it's funny, the determining case on this was, and I forget what town, was that it was okay until the church decided to ask for a tax exemption.
Well, they are tax exempt.
Then it became
They are.
not okay from the
Right.
town.
Yeah, houses of worship, whatever they are tax exempt.
Yes, they are.
I worship a lot in my house. Like the whole
Me
house
too.
and all over my property.
Me
So,
too.
All right.
All right, so response, you'll draft a response to Mr. Donovan, just indicating the gist of the board's position on this. All right, and that brings us to the zoning amendments. All right.
Don't we have another memorandum? Is that a different one? Or did you see
I think we're going to address
That's
that.
on the noise, the different definitions from the noise
That's what
ordinance.
you're
to-
tying back. Okay.
Yeah, Article 3.
Gotcha.
Isn't 7 and 7 normal?
Yep, this is the legal notice.
Can I make a suggestion how we go through these?
No.
Well, we're looking to vote and post these two
Correct.
for public hearing.
Correct.
So do we want to go through each one, and then as we go through one, motion it to be posted for?
I think that's the way we probably should do it.
So, all right, so we'll go through, we'll read one, and then we'll make a motion whether or not to post it for
My,
public hearing.
my suggestion is just we go through it in a specific order, not necessarily numerical order.
If you want to go about it in a roundabout way, that's fine.
Well,
But as long as you're going down the path, you stop and we
Yes.
motion it to, for public hearing.
So the so-called, I call them the one-liners. This is where we had to blow up the omnibus plan. So that is Articles 1, 4, 7, 9, and 10.
1, 4, 5, and 7? No.
No,
1, 4, 9, and 10.
1, 4, 7, 9, and 10.
I forgot one.
My mind, it goes. When you get a certain age, it goes.
I'm there already.
Where's your Article 1 anyways, Dan?
I don't know, I haven't.
Yeah, it started at 2. So it's a 2.
It starts with 2,
Yeah.
so.
Starts with
Hey, listen, I'm responsible for my own copies. I have mine.
All right.
So, well, let me read 1, okay?
All right, so pen in Article 1.
So it really, all it does is create a bad, correct a bad reference. And so this was an amendment to the conditional use permits, section 22084, and
important.
a specific authorization for the conditional use is permitted within, we had Article 5, and the proposed change is the ordinance. Okay? And then 22085 is the same kind of correction, is following a public hearing on the proposed use, the planning board shall issue a conditional use permit if it finds, based on the information and testimony submitted with respect to the application, that A, the use is specifically authorized. We strike out Article 5 and put in the ordinance.
Okay. Shay, do we have these on that SharePoint site?
Yeah, I can,
I think it'd
Yeah.
probably be beneficial to.
they're
you
on
think-
SharePoint and we can pull them up on here as well.
Yeah, I think it'd be beneficial to, just so that,
Additional use permit on. Okay.
I can get them on here, actually. I thought I had put them on here, but I can get them on in just a minute, if that works.
yes, fine.
Awfully quiet.
We're in a hiatus of some kind here.
Huh?
Do you have 4, 7, 9, and 10 in your book?
We just have sentences. We don't have.
No, we just have the summary of the legal notice, not the content.
No, we don't have the contents of any of this.
Got nothing.
Can you get this?
Well,
You
that's
know?
what we're pulling up.
Oh, I know, but I want to copy it.
Yeah. It's,
So they're all here. I'm not sure, Mr. Kane, if you want to come up and navigate through them.
You're going to make me navigate through that? You've already seen my limited navigational skills.
There's a mouse, Mr. Kane.
Oh, okay. So.
Where? Oh, no, what'd you do?
I broke my phone.
Karate tournament.
God, man.
Getting dressed tomorrow.
Kind of, yeah, don't buy a farm.
Is it a Christmas tree, man?
Okay. So this is what I just read. So you can see the changes.
just striking out there and just putting
can see 'em.
ordinance in.
Yeah.
Specific authorization.
The reference we use basically, I'm sure we missed someplace, but we generally are referring to the ordinance as the ordinance versus, if we need to be narrow and get into Article 5, on anything specific, we'll refer to it specifically. But in general, we permit things throughout the ordinance. This captures throughout the ordinance.
And just for context, everything here is what we've been working on.
This is all, these 5 here are, all of them, other than the non-conforming use ordinance, which I'll explain in detail, everything has been
Okay.
before
And
us.
this has come back from legal too.
Yeah,
So-
these are
sorry,
all
so-
been reviewed by council.
All right, so, I mean, this is just an
In
essence.
fact, any changes that were made from previous drafts were a result of council's comments.
All right, so, what is this one labeled? So Shay, I'm gonna motion, we'll motion it, with a second, and if there's discussion, we can discuss, and then we'll vote. All right, so, this is, so if you could show what is that, Z26-1?
Z26-1.
All right, so do I need to indicate the date that we're just saying post for public hearing?
I would note the date for the public hearing,
Yeah.
probably.
And what are we shooting for?
December 4th, right? Is it 4th? 3rd?
December 3rd.
December
Yeah, whatever that Wednesday is.
30?
Whatever that first
3.
December is.
3, okay.
Yeah, just 3.
I can't
A lot of
believe we're
side
already
chat.
talking December.
All right, so I move to post proposed Article Z26-1 at the public hearing on December 3rd.
Are we going to get a copy, though, of all of this before we come?
You could discuss it after.
You guys second the motion?
All right. Any discussion on the subject? Yes. These are all out on the SharePoint site, correct?
That's correct.
Yeah, so
So I can get a copy?
you can get a copy, and, you should already have a copy, but it's on the SharePoint site if you want to visually, go out there and look at it.
Yep.
Right. Any other discussion on the subject? All right, all in favor? Aye. Opposed? Abstained? So 5-0-0 for, that would be Karen, Ms. Robbins.
Doing your regular job?
All right, next, Dan.
Well, Mr. Chairman, you got to pick up the speed here a little bit too, or we'll be here all night.
Just look.
No, we won't.
C26-4.
Is that Z26-4?
Yes, it is. So all here was, we changed the buffers on prime wetlands.
So we skipped 2 and 3.
We did, because they need to go in an order. So
Oh,
just run with me here, guys.
Z26-4, all right. So I move to post Z26-4 to, what's the word again I'm looking for?
To the public hearing.
For public hearing
Public
or
hearing.
December 3rd.
December 3rd, public hearing.
Do I have a second?
Second.
All right, second. All in favor?
Aye.
Aye. Opposed? Abstained?
I'll get us to move this along.
All right. Next.
Thank you. Okay, the next three all relate to changes that were initiated by the state legislature. I know I'll be accused of because it's a farm-related thing, but this is House Bill 272, and all it did was essentially give tie the noise from farms as an exemption. Right now, we had farming equipment and farming activity as an exemption. All it did was really tie this to the definition of agriculture.
So I'll make the motion to move this to a public hearing.
Which article?
Article Z26-7 for December 3rd.
I second it. All in favor?
Aye.
Aye.
Opposed? Abstained? 500.
7.
Okay, let me go down. So next is
Z26. 7.
So this is Z26-9, and essentially adding an appeal section to Article 20, which is the ZBA, and this was House Bill 296. So we actually didn't have appeal language in that zoning ordinance. This comports with RSA 676-52A and B, which essentially now mandates that you have 30 days to file an appeal. The prior thing was an undefined period. Reasonable, I think it was. And the provisions are nailed down, all come from the RSA. So it's the notion when to file an appeal, who it can be filed from. And then the ZBA can hear appeals from planning board decisions related to an interpretation of the ordinance. And we have recent experience with this one. So
Exactly.
All
I
right.
second it.
Okay, I move that Z26-9
Wow,
Posted
you really
a public-
want to move it along.
posted a public hearing December 3rd.
It's like I'm out.
Right.
Second by,
She seconded before you.
You seconded before you started.
seconded by Ms. Robinson. All in
preemptive
favor?
Aye.
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 Opposed? Abstained? 500. Next.
okay, this one I misspoke. This one is not. This one is to. So this is Z2610. What the hell was that?
2610. Okay. Oh, this is that home operations.
Did I not send that to you?
I didn't get it. 10. I didn't-
Okay.
10 is
Got one
home
through nine.
operations.
So let me just tell you what 10 says. So it's conditions applicable to all home operations. It's 22067. So right now, home office is a use that's in the home occupation, and it's allowed as a matter of right. I mean, it's virtually, you wouldn't even know a home office exists. There's a prohibition in there, which the idea wasn't to have multiple home businesses hanging all the way around. So the prohibition is that there shall only be one home operation per lot. Add in an exception for a home except where the second use is a home office. The issue is it's provided by right, and the whole idea of this ordinance, and I know I wrote it, was to prevent like a home daycare and a home business and a home occupation all come from layering on top of each other. It wasn't to prohibit someone from, like me. I have a home office.
Reviewed by legal then.
Yes, it was.
Okay.
Yeah.
We'll make sure that gets to.
Yes.
To Shay.
Yeah.
Second that.
Okay. I move that Z-26-10 be posted to public hearing December 3rd.
Second.
Second by Karen. All in favor?
Aye.
Aye. Opposed, abstained. All right.
Okay, next one. Okay. Z26-8. This is accessory dwelling units. There's a major rewrite from the state as to what can happen now in ADUs. And the draft that was presented to council was accepted 98%. All her comments were, and I had eliminated one of them, which was that we had this requirement that we needed a certificate of occupancy for a sale of an ADU. If the residence where the ADU was somewhat, had nexus to. Well, we don't do that for single family houses. You sell your house, you're not getting a certificate of occupancy. And the notion here from the state was that whatever we require for single family housing has to match the ADUs. That you can't make them necessarily different. And otherwise, you can see this in bold here. Otherwise, it's much of which is just creating some defined terms. And the big change is pretty much that if you have a non-conforming structure on your property and you're not changing the footprint, you automatically have to be able to use that as an ADU.
Yep.
And this is B here where my cursor is. Accessory dwelling units are permitted to be converted from structures existing prior, and it's a limit on July 1st, 2025 when it went into effect, including but not necessarily limited to detached garages, regardless of whether such structures violate current dimensional requirements for setbacks and or lot coverage. So you can't take a garage that's non-conforming and double its size in terms of footprint. But you can use it to create an ADU. It's clear the state wants to expand the use of ADUs, and they've effectively done that. So there were simple things like ADUs had, you can't have in your definition of ADU that it has to match the exterior of the existing, they've wiped all that out. So to me, this is the statutory one. And like I said, it's been vetted through council.
So I move that Z26-8 be posted to public hearing December 3rd.
Okay, second it.
All in favor?
Aye.
Aye. Opposed? Abstained? All right, 500.
Okay. So here's the next one we're going to talk, because this is the one Shay raised. So this is Z26-3. So this is this is Article 3, the general provisions section of our ordinance. The majority of the changes here are defined terms. If the ordinance defined a term, we just corrected it as we went through. I'm generally feeling I didn't go hunting for, and when we had the committee, we intentionally didn't go hunting to correct every defined term, but if we were otherwise going to touch an ordinance, we corrected it as we were in there. So the big thing here is and we'll get into that, we moved all of the non-conforming uses and definitions out of Article 3 to its own article number. Let me just keep going down.
Use storage.
There's a section here on Class 6 roads, which again it's the language out of the statute. And I kept them in red here so we could look at it, is storage containers and storage trailers. The language in here was, and this has been in here for a while, since essentially the beginning, is essentially to be more clear as to where they're permitted and where they're not permitted, and actually define what they are, because we'd had no definition of them. So in the definitions, storage containers and storage trailers are specifically defined. And that's true throughout the ordinance. There had to be over 100 definitions, terms that we used in the ordinance that had no definition. They just existed out of nowhere.
Ex nihilo.
Well, and, some of that gets covered by the kind of plain meaning of words, but, we were using them as a defined term, which generally means they have a different definition than the phrase overall. Class 6 building requirements, this comes right out of the statute. And basically says the burdens on the town can issue building permits, but the burden's on the owner of the lot to make sure that no liabilities being somehow transferred to the town.
All right.
Hang on just for 1 second. I get to care and treatment of animals. Language is relocated from Article 5. We put that, anything that related to the ordinance in general, we tried to put in Article 3, which is general requirements. So the care and treatment of animals, temporary structures didn't change we didn't change the definition. Yes, Nolan, we listened to you. And I didn't want to, as much as Ryan entertains me, I didn't want to see it have a whole meeting of Ryan. And corrals for farm animals were all, hopefully he's not watching and texts me, but again, came from Article 5, just took the language and moved it here.
All right, so I move that Z26-3 be.
All right, wait. Now we have to deal with the noise limits. So the question is in the noise, and you have the paperwork there, and jump in and smack me when I'm wrong, but in the noise restriction in the noise ordinance is more restrictive than we have here. In a sense, because the noise limitation, and it's in 11 right here, 22011. Let's see it. Hang on for a minute.
And the section in 22011 is the one that's also referenced in the site plan requirements. And so that's what gets memorialized on site plans is the construction times that are listed in 22011. But then under the noise limits there, it's in contradiction with it, and they're further limited. But it doesn't look like that's been memorialized anywhere, and it's sort of been missed.
So my thought is we're we're a primarily a residential, community. I think the noise, it's the same time frame, but no Sundays, no holidays. So I don't think that's that big of a
No,
deal.
but I think for the holidays, we're gonna have to list out the holidays. Because what's, like you say, you just went past Veterans Day. A lot of companies work Veterans Day. They don't recognize it.
Yep.
If we want to recognize Veterans Day, then I think we should spell it out. Along with, obviously, you got your obvious ones, right? New Year's,
Christmas.
Memorial Day, Labor Day.
Right.
But if we want other ones, I think we should list out the holidays just so it's clear.
Yeah.
Because somebody could say that's a holiday and someone, no,
I
it's not.
I
Columbus
don't
Day.
think that's a bad idea at all.
Can you say something like just maybe like federal holidays, or whatever? I mean, just, something that you don't need to.
List out all the holidays, yeah. I mean, you could say the federally recognized holidays, right? Aren't there like 11 of those?
Yeah, a lot of companies work on those too.
But yeah,
No, but if you're, and remember, this relates only to construction. It's not like a broad.
I just think it saves us from having to go back again if we figure out which ones we want.
Okay.
Trying to take my work from me, huh?
So we can't put noise limit to fish and game, huh? Just an idea.
Well, one of my suggestions was just going to be to reference the noise ordinance, is reference, just point you into that direction. But again, it doesn't list holiday, that you have the same issue. You got no holiday lists, I believe, in there.
Well, unless you list the holidays the town hall's closed for. That saves you a lot of work.
That's fine.
I mean, if we were doing that, there would just be amended during the hearing, right? Or would you do it?
No, we have until, we're posting all this tomorrow, right?
They were sent to the newspaper on Tuesday.
No, the actual
But they'll be
text.
posted, the full text will be posted online tomorrow.
Okay,
Yes.
so if we make some minor changes, we can still get that in, right?
As long as you're not touching new sections.
Yeah,
Yep.
right. No, we wouldn't change any section numbers. We just.
Yep.
Okay. All right, we can do that.
I'm just trying to think of ways.
No, I don't think that's a bad idea. So if we refer to town closed holiday,
Town hall's holidays.
Yeah.
And it's only referring to new construction.
Right, it's
here. Not-
construction.
Yeah, there's not a whole lot of that going on anymore.
If someone's still having work done in the house.
no, but it's just a logic connection. That
Yeah,
way the
yeah.
ordinance doesn't conflict with each other. Okay.
What if that holiday falls on a Friday? Because then you're technically not even open. Just saying.
You ain't lying.
So let me just.
I guess I would say we would have to look at the list every year and make adjustments for it. But I understand what you're saying.
This becomes like the tail wagging the dog a little bit. Yeah. I mean,
It's probably just open.
I think we put something in there, we account for it, and then we just.
The big one.
It's there.
Easter,
It's there.
Thanksgiving, Christmas.
This is on a Sunday.
Good point.
Yeah.
That's right. Forgot the heathen over here.
So I'm saving 5 and 2. That was the last one I'm going to be over because it
So
really.
we good with 3?
Yes.
So I move that Z26-3 be posted to public hearing December 3rd.
Second it?
All, discussion, all in favor?
Aye.
Aye. Opposed, abstained, 500.
All right. So this is 6 is haven't seen. The board hasn't seen this one. And I'll tell you why. Because we just drafted it Sunday night. And it was, okay? And it was based on, it's based on conversation with council and really conversation that Richard and I had with council over, the issue that was before the zoning board regarding our view of the zoning ordinance. So and I'll give you the Reader's Digest with counsel is,
Just so you know, there is a copy of the notice of decision in your folders, so
And
that's
so-
what we're talking about.
what we were contemplating as we discussed at the last meeting was filing for a notice of rehearing. Because, both Rich and I had serious concerns about the nature, scope, and extent of the ZBA's actual ruling. We had some substantial procedural concerns. But we were also mindful that we don't believe it's to the benefit of the town for two land use boards to be spending town money, arguing esoteric zoning.
Exactly.
Because that expense, this is likely that something that could have matriculated to the Supreme Court. And we became comfortable that the concerns we had were going to be very narrow and limited to this particular applicant, which we had no problem with what they want to do. It was just the process of doing it. So counsel and I chatted, and the solution was to kind of fix the deficiencies, because there were deficiencies in our non-conforming use descriptions, and this is the byproduct of that fix. So what we did is I gave her my ideas for this, and to the extent if she had a concern, I told her, raise them, tell me what to do. She had no concern. So let me just tell you what I did. I basically created a by right.
But
use.
before you do that, though, why don't we?
Can I just explain my thing before I'm interrupted?
Well, I know.
I'm not a freaking applicant.
I know. No, I think it's, what is it that we're trying to cure? What we're trying to cure is that if you have
We're trying to cure is the unfettered expansion of a non-conforming use.
Exactly. And
Okay,
so,
which I personally don't believe would be beneficial to the town. So, but mindful that people can use their property. So try to achieve some balance. So what created here is essentially a by right use that if your expansion of your non-conforming use or use in a non-conforming structure, you can do that by right up to 20% of certain standards, lot coverage, building coverage, gross square foot area. And there are other towns that do that, Then created a second tier of expansion that would require special exception. So anything over 20% up to 50%, you would have to go through the special exception process. And again, it's being mindful that people have the right to use their property, but nonconformity by its very nature shouldn't be expanded in an ordinance. They're designed to not do that. And then I placed the limit that anything above 50% just prohibited, So it seemed to me to be a reasonable thing. I double checked with the chairman of the ZBA in Hanover, New Hampshire, who's kind of the godfather as an attorney. He's the godfather of nonconforming. And he thought our ordinance was extremely reasonable and designed to, he said he might steal some of the notions we have. So that's what this does. It essentially, prevents any leakage, if you will, from non-conforming. At the same time, permitting, some expansion.
yeah, and just to point out that was one of the observations that the ZBA did make, and it was argued that that our zoning didn't say anything about non-conforming being able to be limited in some way. All right.
And
So
I'll just tell you, those definitions of nonconformity, It came in 1993.
Oh,
You know,
very recent.
That was a good year.
Yeah. But, so that's the new piece here, you know, even though 2 and 5 are substantial in the things, they haven't really changed from earlier versions. This is completely new.
All right.
Very good. Second it.
What's that? You're going to second that? What is this again, number? That's 6?
6.
All right, I move that Z26-6 be posted public hearing to December 3rd.
Second it.
All right, discussion?
Yeah, I'm just gonna, I'm gonna abstain because it's the first time I've seen it.
Yeah,
Just so I have a chance to read it.
yeah.
Doesn't mean when it comes time to vote, that's what I'm gonna do. Just
No, I think fair enough. Yeah.
That's all.
No, I mean, this is legitimately the byproduct of the process.
I'm not saying is it, just I haven't.
No, I
had a chance to
know,
read it. That's the only reason.
I'm not being argumentative. It's that the ZBA noted in their decision that our zoning
And-
doesn't have these types of controls.
And again, this is just to get posted to the public hearing.
Yeah.
Right.
We still have to vote on it at the public hearing.
Right,
Right.
which, that doesn't mean that's how I'm gonna vote at the public
Yeah,
hearing.
right.
I just wanna read through it, that's all.
Right,
Yeah.
right.
Any other discussion? No, all in favor? Aye. Opposed? Abstain?
Abstain.
Right. 401. There we are.
Okay.
All right.
Here's, 5 has been around for a while. So 5 is the text of, so what I did here was, it was 67 pages in Article 5, okay? And a fair amount of repetitive language as to all these tables, which I basically converted to an Excel spreadsheet. And instead of having 25 pages, I cut it down to 4. Tried to. And fundamentally in here, just going through, other than capitalizing a lot of terms, I really didn't change definitions. And I specifically moved things. So when I say the care and treatment of animals, I moved that. That was here. I moved it to 3. Corrals, 3. There's at the end here, proposing, it stays in here, but the goal is to move this to excavations. It relates to excavations, should be in that article. Okay. The biggest change in here is essentially, this is something we kind of played around with last year, is that when we have a use that's not permitted or specified, it's game over right now. We have no mechanism to kind of have the ZBA, the code enforcement officer, work at coming up with something that's close. And this use not permitted or specified creates a mechanism for them to do that. And it's really a responsibility of the code enforcement officer.
Yeah. Okay.
Originally, when this language was first drafted, I had in here a kind of consultative piece with the planning board. I was somewhat reluctant to have the planning board start drifting into a lane it doesn't belong in, you know? So I eliminated that from here. And it's a good thing I did, because Laura told me it was illegal anyway, so. So
So just a quick question, in terms of
What's the mechanism? Let's just walk through the thought experiment.
So they have to issue a written determination supported by specific findings of fact, the code enforcement officer, that a proposed use is related to an existing permitted use.
All right.
In some with some materiality, like the traffic's the same, the noise isn't as bad, the odors, it doesn't produce those, and likely impacts on town services and abutting lots. It's fairly stringent, in the
So the
sense.
code enforcement officer would be the
code officer.
Yeah.
would be the individual doing
Yeah.
it.
This is a common
Okay.
provision in many zoning ordinances in New Hampshire. And it recognizes that there are things, you can't possibly list everything.
Is it appealable?
Yeah,
If you get.
everything is appealable.
Right.
It's appealable whether you gave it appeal rights in the ordinance or not,
Right.
Again, as you heard last night, state law trumps local. So,
And rules and procedures, apparently. So.
so we're just trying to.
25.5, right.
I'm just going through this. Just give me a minute just to make sure.
That was number 3, right?
5.
5.
All right, let me get out of this because the big thing here is the table. Okay. So what we did is we created a series of 4 tables. So let's start with the commercial. So these are all the commercial and mixed use districts that have commercial activity in them. So these are, on the left is all the permitted uses. And all these uses have now a definition in Article 2. And then if there's a specific reference in the ordinance to that definition, I've included where you would find it. So most of them are going to be Article 2, but like cemetery and burial has its own ordinance, has its own definition. Okay. And then so C1, C2, C3, the village center, the ICR. The headings are permitted by right, permitted combined, for the ICR, permitted with restriction, permitted by special exception, permitted by conditional use.
Is there a legend for those terms?
Well, they're all defined in the.
Well, just P, PC, PR.
Yeah, see the legend.
All right.
Legendary.
Working on the transition lenses.
Yes, yes.
Gonna come over and step on your.
So these are labeled 32A, B, and C. Same thing for residential. Same thing for industrial.
Right.
And then all the dimensional requirements. So all of these headings up here now have definitions in Article 2. They all didn't.
Got a commercial 3 in it? Yeah, there you go.
We do?
Yep.
And where there's nuances in any specific definition, I have a note on the right-hand side. So like we never defined what a story is in our ordinance. The ordinance now defines what a story is. Well, because it matters because where you are in plane grade and everything. So it does matter. And then these refer to, I'll open it back up. Hang on for a minute. Just you open up 5, I'll tell you. So in 5, there is this application of specific district regulations. So these are just taken right from what was in there, you know. So for industrial use lots, you know, they were concerned about bank and bank kiosks. Commercial 3 districts. There is, you know, multiple buildings, maximum building sizes. These all tie back to the use tables.
All right.
This is a major rewrite of the ordinance. I mean, in terms of presentation and organization. I think in the end, we end up with a more readable ordinance. And at the end of the day, that's one of our jobs, I think, is to try and get this ordinance so it's that anyone who picks it up can go right to, okay, what's the uses in C3? What's the uses in C1? You know, right now you got to go down and read through a bunch of tables and everything. Then you got to go to the dimensional, you know, and it's just it's not a fault of anyone. It's just the way the ordinance has grown over time, and it always needs to be. I mean, I've been through a lot of the town reports, and you can see, you know, every 5 or 6 years, they're making these kind of foundational mid-course corrections on the ordinance. This is just one of those.
All right. So this is 26-5, right?
Yep.
So I move that Z 26-5 be posted to public hearing on December 3rd. All in favor?
Aye.
Aye. Opposed? Abstain? All right, 500.
All right, last but not least. Okay.
Final.
Z26-2. So this is the kind of anchor for the ordinance. It's all definitions. And here, you know, I'll just run through them. Accessory dwelling unit meets the state definition. We didn't have a definition here of accessory dwelling unit. Adaptive reuse meets the requirement of the state. Not that we have adaptive reuse necessarily, but now you've got the permission to have residential multifamily housing in a commercial zone. You know, this gives us kind of some influence of how that's going to be used. And to the extent that people want to do something with housing in an existing building, it has to be in a commercial zone. It has to have some level of retail space to it, you know? I mean, it would be hard in our town, given that, you know, everything's kind of single story.
Right.
So,
But anything new?
we're using the term of approved plan to refer to site plan or subdivision plans in the ordinance without any definition. Bank kiosk. These were all existing terms, okay? Building coverage, building footprint, and building area were not. They're terms, but we were using them in the tables of dimensional requirements without defining what they were.
It's kind of floating around.
business office is just a clarification of brand, it's generally to make sure we weren't limiting ourselves to profession services. Cemetery burial site, we didn't have a definition, we had a use. Class 6 road, we have a regulation, we had no definition. Clinic, again, we had no definition. Commercial equipment, commercial recreation, again, no definition. Construction equipment, we use the term, no definition.
Contractors.
Corrals for farm animals, we had a whole section, again, not with no definition. Multifamily and dwelling, it didn't really change the definition, just we used the terms duplex and things like that throughout the ordinance with no definition. And we had to, let's see, yeah, we're, right. Yeah, families. So the state has barred being able to limit use of any property to people who are related by blood or anything. So you had to broaden the definition of families. And it was easy to do it here than go tweak every item in the zoning ordinance, you know? Farm animals, we use it in the ordinance. This just ties everything back to RSA 2134. Same thing with forestry. Fraternal services and charitable uses, another use that had no definition. Funeral establishment as well. This is where the stories comes in, grade plane, because it's based, how you calculate a story is from the grade plane. So that establishes the base of what you calculate a story from. Gross floor area, again, was part and parcel of how we were dealing with nonconformity. So we just kind of tweaked that definition. We had a phrase, high hazard use in the ordinance. We didn't have what it was. Hospital, hotel, we use hotel, but we did have a definition of motel, so I just pointed it in that direction.
Industry.
Impervious surface, I just gave examples of what that surface would be. Industry heavy used to have this piece in there that said, the planning board would determine what it is, that's not lawful, so we took that out. Let's see, local legislative body, just as a town, again, we refer to that as a defined term. Lot area, we use the phrase lot size, but we didn't define that. Just define what lot area is. Medical office building, just defined what that was.
What size? You're not going to do frontage.
So here's the non-conforming language, which really tightens up. So we never had the definition of non-conforming structure. And our lot definition was, in the opinion of our council, probably overly broad, because we had that it had to meet all requirements of the ordinance. Typically a lot's only meeting like lot area or frontage. So
yeah, so they did have frontage though.
Yes, but no, they didn't. They had no. We had the word frontage, but we had no.
Oh, I thought.
So really, a non-conforming lot in our town is only one that doesn't conform to frontage. Lot area has always been exempted, which is, to me, fair. If the lot has the right amount of frontage, you can figure out how to use it. You should be able to figure out how to use it.
Yeah, you gotta make sure it has front.
Non-conforming structure created a definition, you know? Non-conforming use, the only word and phrase we added is what would make it non-conforming and that it's not a permitted use under the ordinance. We use the phrase pervious surface in some places in the ordinance without having a definition. We put it in there. So the church, the place of worship, I would like to replace that with instead of the language you see here,
Yeah.
a building or structure where people gather to pray, worship, or conduct religious ceremonies. And then places of worship are permitted in all districts.
Yeah, that's actually better.
Yeah, this starts to limit it to, and it's kind of inconsistent, I thought, with the RSA, but yeah, so I will make that change. Private, public, non-profit recreation wasn't defined. Private public schools weren't. Private service club, produce stands, public use limited to public safety and service facilities, publishing, rail service and rail stations. And these are all uses in the use tables, you know. Residential care services, which is nursing homes and the like. Research and testing labs, another one that wasn't. Self-storage warehouse, which we didn't have.
No.
So setbacks, again, this relates to that, those dimensional tables, created definitions so that they match up. And it's consistent to how we were using the ordinance, it's just the term wasn't in there.
Storage containers, storage shelter.
One of the things that always troubles me is if we're using a term, we should know what that term means, because otherwise we suffer the smarmy attack, you know, is it's not in your ordinance, therefore you can't do it, and yada, yada, yada. Storage containers and storage trailers from Article 3. Story above plain grade. Theaters wasn't, even though we have no theaters, but they're permitted, but
Nice to have one back.
yeah. Urgent care facility, again, another definition. So the vast majority of these. I just tighten the definition of violation the way we use it in other aspects of the ordinance. Zoning officer, I match to code enforcement officer, the same definition. Those are it.
Very good.
Right.
Very well done.
I move that Z-26-2 be posted to public hearing December 3rd.
Second it.
All discussion. All in favor? Aye. Opposed? Abstained? All right, 500.
All right. Thank you for your patience.
Thank you, Dan. That was a
Thank you,
tremendous
Dan.
amount of,
A lot of work.
tremendous amount of work.
Yeah, hours.
I'll get you those chains.
All right, I think given the time, we can,
This is good.
is there any last, anything that we need to be aware of? Going into pressing. I'll just say that there was, we did have the traffic calming. We had a public hearing on it. And I kind of like the idea that I heard the selectmen saying something, maybe a working session or something like that. But, you know, maybe the planning board wants to sort of opine with respect to where we want, what our imperatives are. So I guess maybe that's, is there a comment period? Do we know how long that's open for?
I am not aware.
All right. So we can look and see how long the comment period is, and then maybe we can, roll that into one of our work sessions or something.
I still wanted to see that, transportation, which that would include as part work on the master plan.
Yeah, no, I'm just thinking the traffic calming in terms of like, we had a presentation.
I know, but it would
And then-
involve everybody.
And then, something that we could probably send to the consultant and stay. So, anyone else have anything else? If not, then I'll close this meeting at 9:04. Thank you. Thank you.